Good morning, everyone. This is a live stream of a hearing, an appeal from Mauritius. I am Brian Kerr, I'm the presider in the case. We have Lord Lloyd Jones, Lord Briggs, Lord Sales, and Lord Hamblin. And appearing for the first appellant is Mr. Guthrie, QC, and Mr. Duval is for the second appellant. Mr. Perry QC and Ms. Victoria Ailes appear for the DPP. So if everyone is ready, I suggest that we invite Mr. Guthrie to present this case for Mr. Lagesse.
Thank you, my lord. Can I just confirm that you can hear me now?
Yes, indeed.
There are just two housekeeping matters to begin with. I hope that your lordships have received a short supplementary note with some additional material. I apologize for its lateness, but it mainly relates to a matter that only reared its head last week.
Yes, we have received that, and as you say, it's a fairly peripheral matter.
Yes. My lord, the second matter is to mention something that I'm sure is already clear. Some of the page numbers, as you have them, have two numbers at the foot. It is always the number in the bottom right-hand corner, which is the relevant page reference.
Right, thank you very much.
My lords, you've assured us that the board has been able to look at the underlying material. I propose to deal with the issues following the scheme of our written case. As you know, the case concerns an appeal by the Director of Public Prosecutions from the Intermediate Court to the Supreme Court. And the first question is whether the Supreme Court was correct to make an order for a new trial in the absence of a serious irregularity in the trial before the Intermediate Court. My lordships, can I ask you to go to the relevant legislation straight away? The Act is under page 1471 of the electronic bundle. The relevant sections are at page 1472 to 1473. 1474, I should have said. Section 92 of the Act gives the right of appeal from the Intermediate Court to the Supreme Court. And under Section 92B, that right includes the right of the Director of Public Prosecutions to appeal against any dismissal of a charge, or in the case of a conviction, against the imposition of any sentence. This case involves the appeal against the dismissal of a charge against the appellants. The powers of the Supreme Court on such an appeal are dealt with in Section 96 of the Act. And you will see that under Section 96, subsection 2, subject to sections 3, 4, and 5, the Supreme Court may affirm or reverse, amend or alter the conviction, order, or sentence, and may, if the order made or sentence passed is one which the trial court had no power to make or pass, as the case may be, amend the judgment by substituting for the order or sentence such order or sentence as the court had power to make or pass, as the case may be. My lords, subsection 2 is therefore expressly subject to subsection 5, and if I can ask you to turn the page electronically, subsection 5 provides that where on an appeal under Section 92, the Supreme Court is of opinion that a serious irregularity has occurred, it may declare the trial to be a nullity and order a fresh hearing. So on such appeals, the the Supreme Court, as the appellate court, may affirm or reverse, amend or alter the conviction, but under subsection 5, it may only order a new trial if it is of the opinion that a serious irregularity has occurred. My lords, the question arises what those words mean. What constitutes a serious irregularity? And in our submission, it's clear from the language itself that that must be something that would enable the court to declare the trial as a nullity. The meaning of those words is plain. My lords, at this point, may I ask you to look at another piece of legislation. It is one of the attachments to the supplementary note that your lordships received at the end of last week. And it is the Criminal Appeal Act. My lords, that provides for appeals from the Supreme Court to the Court of Criminal Appeal. And I don't know if your lordships are able to turn that up. As I say, it's not in the electronic bundle, but your lordship should have received it electronically. If you have it, can I ask your lordships to refer also to paragraph 5 of my note, my supplementary note, which really sets the point out. By section 5 of the Criminal Appeal Act, the Director of Public Prosecutions is also given a right of appeal to the court against a final decision of the Supreme Court or a verdict of the jury where a charge has been dismissed or a person has been acquitted. And what I'm reading, section 5(2)(a) of the Criminal Appeal Act. Section 6(2)(a), which is on the next page, provides for the powers of the Court of Criminal Appeal on such an appeal from the Supreme Court against an acquittal by the jury. And you will see under that section that on the dismissal of a charge, the court may affirm or reverse the dismissal of the Supreme Court and substitute, therefore, the appropriate determination or order a new trial. But under subsection A, subsection 2, it may declare the trial to be a nullity and order a fresh hearing where the court is of opinion that a serious irregularity has occurred. My lords, that, in our respectful submission, shows that under the Criminal Appeal Act, a new trial can be ordered in all cases, and not only those in which a serious irregularity has given separate treatment. And we say that serves to confirm our understanding of what is meant by serious irregularity. In other words, something which enables the court to say this trial was a nullity and not a proper trial at all. My lords, in relation to those two contrasting provisions, I've done a little more research, and the Criminal Appeal Court, sections 5 and 6, which I've just shown you, were the result of amendments, most recently in the years 2000 and 2013. The amendment in 2000 was what gave the Director of Public Prosecutions a right of appeal against sentence. And the sentences that I've shown you, which gave him a right of appeal against conviction, were added in 2013. So, as I've said, they treat ordinary situations and serious irregularity cases on a different footing. My Lord, there was no corresponding amendment to the district and immediate court and intermediate courts Criminal Jurisdiction Act. And we say that that state of the legislation, in contrasting appeals from the Supreme Court with the appeals from the intermediate court, serves to support our interpretation of what serious irregularity means.
If Mr. Guthrie, it is shown that the first instance judge wholly misconceived the import of the relevant legislative provisions and approached the question of the guilt or innocence of the appellant in a manner which was inappropriate, would that not constitute a serious irregularity?
We would say not so, and that is not the way in which the legislation is interpreted in Mauritius. It would have to be something more than a mere mistake or misdirection by the magistrate himself. In this case, there was a lengthy and detailed trial at first instance, which resulted in the acquittal of Mr. Lagesse and Mr. Seeburrun. It proceeded according to plan, so to speak, and there was nothing which occurred which could properly be described as a serious irregularity in the sense of enabling a court to describe or to declare the trial a nullity. And that is our case on that point. And as I've said, it does not appear to be the manner in which a serious irregularity, certainly seems to have been seen in the manner I've put forward by the courts in Mauritius so far.
You've given us a couple of examples of what you consider would constitute a serious irregularity, such as, for instance, the failure to hear an irrelevant witness. But if your submission is correct, it follows, does it not, that there is a very severe circumscription on the efficacy of the right of appeal, which was conferred on the Director of Public Prosecutions?
Well, my Lord, I'm going to deal with that, if I may, in a little more detail. Can I make good the submission that I've made that the matter is understood in this way in Mauritius by asking your lordships to look at the case of Lamto? That is a case which you will find at page 1443. And the relevant passage is on page 1452. Well, it begins at the foot of that page, if your lordships have that.
1452.
At the foot of page 1452, there's a paragraph which begins, we must add that prior to her motion for a retrial before a different magistrate, the initial stand of State Counsel was that this court was empowered by Section 96 to review the evidence, etc. And the issue of a new trial is dealt with from the top of page 1453.
Yes.
The court...
Mr. Guthrie, this may sound a pettifogging concern, but I think your pagination is one page away from mine, and I suspect everybody else's electronic pagination numbering.
I'm sorry to hear that, my lord.
I think we can all
1453.
If we all add one page, I think we'll be on the same page as you.
May I ask, Lord, how your page 1453 begins? Does it not begin with the words, we shall now consider the motion?
No, it begins with a 10 in the middle of the page and then some italics. And 1454 begins with the passage which you've just identified. I may add that you're quite right about the numbering of the pages at the bottom right-hand corner of the page.
Yeah.
One doesn't use those for finding pagination, one uses the number box at the top. It's not an uncommon problem, and it's only one page apart, so I don't suppose we're looking to
I wonder if all your lordships are in the same position, because I see Lord Sales is shaking his head.
I'm in the same position as Lord Briggs. What about Lord Sales?
My page 1453 seems to be the same as Mr. Guthrie's, beginning, "We shall now consider the motion."
I think Lord Jones as well.
Yes, my page beginning, "We shall now consider the motion," as printed at the bottom right-hand corner, 1453, but my reader tells me that it is actually the electronic page 1454.
Yes, I think you're in the same position as Lord Briggs and myself. What about you, Lord Hamlin?
I'm in exactly the same position as Lord Jones and Lord Briggs. So the electronic number is one out.
Well, if it's only one out, my lord, I think we can probably
Yeah, sorry, I now see I'm in the same position as well. My read is doing the same.
Good. Well, I'm glad that you're not the odd man out.
Well,
Right.
my lords, I'm working from a hard copy, so I think I'm one page behind the electronic. Is that the position?
Well, don't worry. I think we're now, so to speak, on the same page.
Yeah. Well, I was looking at the page which does begin, "We shall now consider the motion of State Counsel for a retrial." And then the second paragraph, learned counsel for the appellants has referred us to 20 decisions of this court on circumstances in which this court has held there was a serious irregularity warranting the exercise of its powers under section 96(5). And my lords, we have supplied copies. I'm certainly not going to ask you to look at them all, of these cases. The short point is that you will find, I'm sorry, I should have said this, you will find them in the footnote, paragraph 18 of our written case. The page reference for that is, well, either 986 or 987, I think. But the footnote includes a very brief description of the relevant issue which justified the description.
Take it that we've read the footnote.
Yes.
We haven't read the cases. We certainly.
Well, I'm not going to ask you to read the cases, my lord, but they're all very short as it happens. But the point is a very simple one. They all use the terminology of section 96(5), that is, of serious irregularity and nullity. And if you look through the very short descriptions, you'll see what is meant by that. It involves such things as a refusal to allow legal representation or refusal to allow cross-examination or some basic fault. One or two cases seem really rather extreme. People have been sentenced before the end of the prosecution case and things like that. But there is a related point to these 20 cases, my lord, is that one may ask the rhetorical question, where is the list of cases where a new trial has been ordered, where there has not been a serious irregularity in the sense, in the ordinary sense of the words? And this is partial answer to, I think, my lord's question to me. Does this not circumscribe the right of the Director of Prosecutions to appeal? It's apparent that I mean, the Director hasn't produced any cases which demonstrate him exercising a right of appeal, except in these serious irregularity cases. And we would submit, and I'm going to come back to this, that it's perfectly sensible to restrict the right of appeal from the magistrate's court, or the right of appeal, or the right to a retrial from the magistrate's court. I will come back to that. But may I just go back to Lamto? You'll see how the courts dealt with it. Counsel, I'm reading on from the, in the third paragraph, learned state counsel has for her part submitted the seriousness of the offence, coupled with the compelling evidence against him, strong and persuasive reasons. Learned State Counsel has also prayed in aid section 82(1) of the Constitution in support of her motion for an order for a new trial of counts 1 and 2 in the interests of justice. And I ask you to note that the court did consider there the power under the Constitution. Then they say, suffice it to say, we agree with the submissions of learned counsel. The magistrate's failure to analyse and consider evidence on record and his misdirection in law in equating knowledge and possession do not constitute a serious irregularity, thus justifying us in remitting the case for a retrial. And they say, after citing the section, to hold otherwise would create a situation whereby each time a trial court either misapprehends or fails to analyse the evidence adduced before it, or draws the wrong inference, or misapplies or misinterprets the law, thus rendering unsafe a conviction, the case would then have to be remitted back to the lower court for a fresh trial. It would also unfairly allow the prosecution to perfect its own mission at trial stage by giving it a second opportunity. They plainly take the view that simple misdirection of the magistrate by himself, or misdirection or misapplication of the law by the magistrate, is not a sufficient matter to constitute a serious irregularity. And one respectfully submits that the court is plainly right to do that. A serious irregularity in the section must be something which would be sufficiently serious to enable the court to declare the trial to be a nullity. Lord Sale.
Yes. I'm wondering whether the court is right to say that each time a trial court makes misapprehends or fails to analyse the evidence adduced, there would have to be a retrial, because section 96(5) simply says the Supreme Court may declare the trial to be a nullity and order a fresh hearing. So right. Why is there not a discretion in the Supreme Court, if it thinks a serious mistake has happened, to consider whether there should be a retrial?
There's a discretion if there's a serious irregularity. There's not a discretion if there's not a serious irregularity.
I know, but the point being made by the court, as I understand it, is to treat the idea of serious irregularity as something very narrow, because it thinks that each time that a serious irregularity is found, the Supreme Court has to order a retrial. And I was just pointing out, one's not necessarily driven to that interpretation because there is a discretion.
No, I quite agree, my lord, but the discretion only comes into operation in our submission if the basis for the order of a retrial is established. And then, and this is a matter which...
I think that perhaps you're misapprehending Lord Sale's point. The court in this case appears to be the that in every case where a serious irregularity was identified, there had to be a retrial, and that's undesirable. Whereas, as my Lord Sales points out, that is not the situation. You don't have to order a retrial in every instance where a serious irregularity has been identified.
Well, we don't go so far as to say that it would be necessary to order as far as the court then. I'm sorry, was my microphone on when I said that? Yes. Yeah. I'm sorry.
It was. Yes, I heard you. Right. Yes, Lord Briggs.
Yeah, yes.
Mr. Guthrie, if there is a sort of undistributed middle between a serious irregularity which would lead to a retrial and some other defect in the process which merely leads to an acquittal being set aside, does that leave the prosecution free to bring a fresh prosecution, there having been no acquittal or conviction, subject to any question of limitation?
Well, I'm not sure that I've entirely understood that question. I don't believe there is an undistributed middle. In our submission, there is only on the legislation the clear meaning that a retrial can only be ordered in the case of a serious irregularity. In other words, something which entitles the court to declare that the trial was a nullity. And we say that that cannot follow.
Different question. He's asking, let's take this case as an example. Let us suppose that there was a decision by the Supreme Court decided that the magistrate had approached it in the wrong way. And let us suppose that it then said, well, we'll adopt Mr. Guthrie's interpretation of section. Would it be open to prosecuting authorities to institute fresh proceedings?
Well, no, because there would be an acquittal which could not be set aside.
Is that right?
Yeah. Well,
is that right? Because the court's power to
sorry, Lord Briggs.
The court's power to set aside the acquittal or the conviction, i.e., to allow the appeal, isn't dependent upon serious irregularity. It's just the power to order a retrial. So, as I see it, the court could set aside the, in this case, acquittal on the prosecution's appeal by allowing the appeal, even if it didn't find what you categorize as a serious irregularity, but then would apparently have no power to order a retrial. But as I see it, subject to limitation, that might leave open the prospect that there having been neither an acquittal nor a conviction, the prosecution can just start again.
Well, I suppose part of the answer is it doesn't appear that that has ever happened. But it might, I would respectfully submit that the powers of the Supreme Court to order a retrial, which, as we'll see in due course, were not considered by the Supreme Court in our case at all. They are circumscribed by the clear words of the section. It may only do so.
I don't think that Lord Briggs' question is addressing that at the moment at all. But if the court has the power to set aside the acquittal,
Yeah.
decides that we're not going to order a retrial, well, the acquittal is at naught. What is to prevent the prosecuting authorities from instituting?
Well, my Lord, the court has the power under section 95 to substitute a conviction. And as we shall see, that is what has happened when the DPP has made appeals. And that is what his remedy is. If the if one looks back to the words of the section, if I may go back to those, it may one has to
Mr. Guthrie, that we're aware that it's open to the court.
Yeah.
But I think probably we've taken the point as far as it can go at the moment.
Well, very well. I'll move on, my Lord. Yes. Well, I think the next thing to look at, my Lord, is section 82, subsection 1 of the Constitution, which you'll see that the Supreme Court referred to in Lambto. And that is at page 1155 of the authorities, or the hearing bundle. If I'm sorry if I'm struggling. I'm slightly more. I'm sorry. Is it your Lordship's 1156? I can see that it's Article 82.
Right. Yes.
1, and that refers to the power of the Supreme Court to supervise civil or criminal proceedings, making such orders, issuing such writs, and giving such directions as it may consider appropriate for the purpose of ensuring that justice is duly administered by any such court. My Lord, the reason it's necessary to look at that section in particular is because it was referred to by your Lordship's board in a case called Dosseroot or Dosseruth.
Yes.
Which, yes. Now, my Lord, before I ask you to look at that case itself, can I make two preliminary points about it? In our case, as opposed to Lamto, there was no application at all for the court to exercise such a power. And the court, in due course, made, as you will see, made no reference to Section 82(1) of the Constitution. In Lamto, there was an application, and counsel relied on Section 82(1). We also make the point that this was not a case in which the due administration of justice required the exercise of any such power, because there had been a lengthy and satisfactory trial in the intermediate court, which in our submission was a fair and unexceptionable trial. And so there was no occasion for the use of the powers conferred by Section 82(1). I should also make the point, before I take your Lordships the detail of Dosseroot, the respondent's case is that Lamto, which I showed you just now, was wrongly decided because the court there was unaware of what the board had said in Dosseroot. That is the what I think my Lord Cole referred to as the peripheral issue, which is dealt with in my note. But it is quite apparent. It's quite apparent that the court was aware of Dosseroot because prosecuting counsel relied on a case which cites from Dosseroot in some detail. And indeed, I've included as one of the documents with the supplementary note the transcript of the hearing before the court in Lamto, which my learned friends produced last week. It's a slightly unusual position, but on page 11 of that transcript, there is a citation from the judgment in Dosseroot. The counsel for the prosecution refers towards the bottom of page 11 of the transcript, saying their lordships held the constitutional, it should be rather than constitution of, guarantee of a fair hearing in section 10 subsection 1 requires that a generous construction should be given to the expression serious irregularity. Now, that comes directly from the judgment in Dosseroot.
Yes, was it?
In any event, it's a direct quotation from law. Yes, and I'm going to come back to it, but perhaps I mean, that is a peripheral point, but it's wrong to suggest that the Supreme Court in Lamto was somehow unaware of what had happened in the Privy Council. But I've also included in the supplemental material the case of Ramdeen, which is where which was certainly before the court, as we've seen. But I don't want to take unnecessary time on that. But if I can go to Dosseroot, which is at 1299. I'm sorry, my lord, due to my current circumstances, I'm a little more circumscribed by heaving bundles around than I would normally be.
It's actually 1,300.
1,300, yes, I'm sorry.
Yeah.
Very briefly give you the background. For a note, it is summarized, the background, in paragraphs 28-30 of my own written case, which is at page 9988. But the facts of Dosseroute were that the appellant had brought a constitutional motion claiming that he'd been denied a fair hearing in the intermediate court because fresh evidence had come to light which might have proved he was innocent of the offence. His constitutional motion was dismissed, and his appeal to the board was also dismissed because, well, the reason for dismissing it was the board didn't consider there was any substance in his underlying complaint with regard to fresh evidence. And it was in this context, having so decided, that they considered the additional ground that the appellant relied on, namely the absence of a right to a retrial under Section 96 of the Act. The relevant passages in the judgment will begin on page 1308 in paragraph 23. See that Section 96(5) is referred to. Yes, and then Lord Hope says in paragraph 24 that the argument is not right. The right of appeal is a right to a rehearing of the case under Section 96(1). We're talking, of course, here not about a right of the DPP, but a right of the appellant. It's in that context that Section 96(1) provides that no new evidence shall be admitted. This means that the appellate court must proceed on the facts which were put in evidence before the trial court. But Section 96(5) must be read in conjunction with Section 82(1), and then that's recited. It's not necessary for proceedings for constitutional relief to be brought under Section 17. It's available to be exercised generally, and Section 82(1) is in the widest terms. Among the orders that may be made is an order remitting the case to an inferior court. So this may take account of additional evidence. The court also has power under Section 96(5), if it's of the opinion that a serious irregularity has occurred, to declare the trial to be a nullity and order a fresh hearing. Is open to the appellant, in this case, to contend that there had been a serious irregularity trial if, as he contends, he was convicted on the false assumption that the incidents which was in the evidence could not have happened as the witness said. The constitutional guarantee of a fair hearing in Section 10(1) requires that a generous construction should be given to the expression serious irregularity. But the appellate court was not asked by the appellant on his grounds of appeal to exercise this power, so the point was not tested in that court. Mr. Oliveri sought to avoid this objection by saying that there was no serious irregularity, but it's hard to see why this was so if the appellant was convicted of participating in a transaction that on the account of the witness could not have happened. The Lords, the points to be made, I think, are that the judgment in Dosseroute, and this, of course, was a subsidiary point, and we don't disagree with it in any way, but it's not clear to what extent the use of the power was argued, or the use of the power under Section 96(5) was argued. The judgment of Lord Hope does proceed on the basis that the powers under Section 81(2) might be exercised where they were invoked by one of the parties, or the appellant in that case, and were needed either to set aside a possible miscarriage of justice or where a serious irregularity had occurred. And in the present case, as your lordships will see, the question whether the court should order a new trial was never raised or argued by the appellant in the Supreme Court, or by the respondent. I'm sorry, I should have said the appellant in the Supreme Court, who was, of course, the present respondent. Whether there was a failure by the intermediate court to administer justice, justifying the use of Section 82(1) was simply never argued at all or considered by the Supreme Court. Next, on the basis of dossier route, it's obvious that the board considered, and part of the reasons were that the appellant might have submitted on appeal to the Supreme Court that the fresh evidence point was sufficient to amount to a serious irregularity, so as to trigger the power to order a new trial under Section 96, subsection 5. But, as the board said, the court was not asked by the appellant in his grounds of appeal to exercise this power, so the point was not tested in that court. Now, in the present case, the Supreme Court was not asked to exercise its power under Section 96(5). But in our submission, it would not be right to suppose that it could have identified anything that could properly be described as a serious irregularity, which would have justified it to declare that the trial was a nullity. That's a point, of course, which I've already made. But there was nothing in the present case remotely like the fresh evidence point which was being considered by the board in dossier route. And even given the most generous construction to the words, there was no serious irregularity, Mr. Baungali, who represented the deputy, who was the deputy director of prosecutions, and he conducted the case for the director in the Supreme Court, he didn't suggest that there had been a serious irregularity, and nor did the court itself suggest that there had been a serious irregularity. We also respectfully say, my lords, that the general power in Section 82(1) of the Constitution should not be regarded as a means to bypass the specific powers which are provided by Section 96 of the District and Intermediate Courts Act. The legislature, and this is a further answer to the point raised by my Lord Kerr as to the restriction of the director's powers, the legislature must have attended, we say, that in the case of appeals from the Intermediate Court, which are treated differently from appeals from the Supreme Court, the administration of justice in Mauritius only requires a new trial where the first trial is a nullity. And this indeed may itself be regarded as one aspect of the administration of justice in Mauritius. We say there are good reasons why the legislature might wish to restrict the power to order a retrial in this way by Section 96, subsection 5. In the ordinary way of things, retrials are not desirable if they are not necessary, if they can be avoided. They perpetuate uncertainty, and they're inconvenient and unsatisfactory for a number of reasons, including those identified in the last part of the citation in the judgment of Lamte, which I took you to. They give the prosecutor a second bite of the cherry. So it's therefore reasonable, in my respectful submission, for the legislature to have restricted retrials to those cases where the validity of the trial process has been affected by serious irregularity, in which case the trial concern will be declared a nullity because there hasn't been a proper trial at all. And my Lord, to conclude this part of our submissions in the appeal, it's not correct to say that there is little point in giving the prosecutor a right of appeal at all, because it would be futile. And Lord, that's, I think they put it rather more strongly than my Lord Kerr did, saying restricting the rights of the DPP. The Act plainly gives the DPP, or gives the court the power to substitute a conviction. That's expressly provided for by Section 92. The powers referred to in a case which we have in the bundle, which is also referred to by both parties, called the Director of Public Prosecutions and Ali Abdel Qadir Mohammed and others. It's in the bundle at page 13, I think it'll be 12, my lords, 11 in mine. That was a case in which the court ordered a retrial but it's again a clear, serious irregularity case. The court declined to substitute a conviction and ordered a retrial. But if one looks at the case, one sees that it falls directly within the principles which we submit apply, that it's necessary for there to be a serious irregularity. At page 1324, we see just to summarize, this was a piracy case. Mauritius took on the burden of prosecuting Somali pirates because Somalia itself didn't have the ability to do so. And this was, I think, the first major case, which obviously went very badly wrong indeed. And one sees at page 1324, the court failed in its duty to assess the evidence, make a finding as to whether on the evidence adduced, the act of violence against the vessel concerned was committed by the 12 respondents, or whether they had no involvement in the act of violence but were innocent fishermen. So in other words, the magistrate, if you like, ducked the one issue that the trial was all about. And it said at page 1329 that there was a serious irregularity. The client, in those circumstances, a real trial was ordered. The powers of the court to substitute a conviction are referred to at page 1332, but I think my lords have already stated that they have, so to speak, noticed or accepted that there is a power to substitute a conviction. And that is what can happen. I mean, in a clear case, a conviction will be substituted. My lords, for completeness' sake, I have included in the attachments to my supplementary note a case called Senek, which came before the board some time ago now, and involved an offence alleged against the editor of a newspaper and the that was a case in which the Supreme Court substituted a conviction, and your lordship's board set that conviction aside. But it's a clear example of the Supreme Court substituting a conviction because it considered that the director's appeal should be allowed, and that is on our respectful submission an answer to the point that really the section 965 makes the director's powers futile, but they're not, and they are different in an appeal from the intermediate court to the Supreme Court than they are from the Supreme Court to the Court of Appeal. That really concludes my submissions on the first part of the appeal, and move on to the further points, which I think, my lord, will take up rather less time. There is an element of overlap. The next question which we ask in or we suggest must be considered is whether or not the decision in the intermediate court was wrong at all. But there is an element of overlap with the previous point, because as we say, even if the magistrate did misdirect himself, all that really can be said is that he mistook the approach to the provisions in Part C3 of the first schedule to the Excise Act, and that, on any view, is not a serious irregularity. But we don't accept that that view of his judgment is correct, or that the Supreme Court was correct in finding that the magistrate made any mistake. As I say, it would not be an answer to our first point if he did. It would not have been a basis for an order for retrial. The Supreme Court judgment, which I go to next, is at page 756 of your lordship's record. Well, it does in my version, certainly, but I thought perhaps it might be 756 in yours, but
Not to worry.
I think it's important with respect to bear in mind that the first appellant was charged with conspiring to evade payment of excise duty and taxes. Sorry, did my lord have his hand up?
Yeah, no, good.
And at page 761, the court said that it did not propose to embark on a detailed consideration of the distinction between evasion and avoidance. But this was, in our submission, really what was at the heart of the case. At page 762, the court referred to W.T. Ramsey Limited and the Inland Revenue Commissioner and the speech of Lord Wilberforce. My Lord, it's really the first two principles which one needs to look at. Under one, a subject is only to be taxed on clear words, not on intendment or on the equity of an act. Any taxing of Parliament, Act of Parliament, is to be construed in accordance with this principle. What are clear words is to be ascertained on normal principles. These do not confine the courts to literal interpretation. And principle two, a subject is entitled to arrange his affairs so as to reduce his liability to tax. The fact that a motive for a transaction may be to avoid tax does not invalidate it unless a particular enactment so provides. It must be considered according to its legal effect. The court then proceeded to look at the principles of construction and reached the conclusion that it was necessary to look at the transaction as a whole. And this led to the basis of the Supreme Court's criticism of the magistrate. And the criticism is summarized, set out on page 769 of the court's judgment, between lines 10 and the bottom of the page. And the court said, "It appears to us that the learned magistrate was wrong in law in adopting a literal approach to the regulations involved, rather than looking at the whole scheme and the intention of the legislator in enacting that scheme. Secondly, the learned magistrate was wrong in law in looking at each of the steps undertaken by the respondents independently, rather than looking at the whole scheme put up by the respondents and the motive behind same. It is arguable at the end of the day that the owner on paper has never exercised any of the rights which an owner of a car would normally exercise, and here the weight of the financing agreement in maintaining the state of affairs demands to be analysed thoroughly. In these circumstances, we consider the learned magistrate ought to have given consideration to the question whether the respondents have purposely used the returning resident scheme as provided for in the excise amendment regulations to circumvent section 158(1)(a) of the Customs Act. That was not done in the present case. Just in passing, may I simply note the use of the word circumvent, which in our submission is at best ambiguous and will be applicable to both evasion and avoidance. The point we make, my lords, is that these complaints about the magistrate's decision are not justified. His judgment, my lords, is at page 298 of the bundle. But the part I wish to take your lordships to in particular is at page 317, possibly 318. It goes on over 2 pages. And what the magistrate says is, in the present matter, I'm looking between lines 30 and 40 towards the bottom of the page. In the present matter, in the light of the facts admitted by all three accused parties and other evidence highlighted above, it can reasonably be inferred that there was an agreement between the three accused parties for accused number 2, that's Mr. Seeburrun, to import a car from the UK to be ordered by accused number 3, that's Mr. Toolsey, the dealer, by using the returning resident status and therefore benefiting from concessionary rates on duties on the imported car under the returning resident provisions of the Customs Act, the purchase of which car would be financed by accused number 1, who would then be allowed by accused number 2 to use and have possession of the same car in return. Of course, accused number 1 is Mr. Lagesse.
Whether this entire scheme was a sham.
Well, the use of the word sham was one of the matters which I dealt with a little bit lower down the page in the decision in Lord Wilberforce's judgment. The question whether it's a sham means that it's not what it appears to be on the papers, but there wasn't any disguising of the scheme. The point I'm making is that the magistrate made it clear that he understood very well that this was an agreement which was intended to circumvent, to use the Supreme Court's words, the liability for, sorry, I choose my words carefully, to arrange the situation in such a way that the returning residence concession could be invoked.
Should he not have gone further and asked himself the question, which on its face was ever capable of realistic fulfillment? Here was a teacher returning to Mauritius. He'd been owned 143. Mr. Lagesse, on his arrival at, he may have handed it over. In any event, in Mr. Lagesse's possession, the agreement recorded that which of course happened to be the period during which the concession on excise duty endured, that it would be £143,500 would be
well, my lord, I think if I prospect. Well, my lord, if I can just interrupt from to make one correction. That agreement was never made. It was a paper document which was not signed by both parties. But the fact
it had been made. Well, all right, let's assume that it had been
one
made.
should make that assumption. But
other than a sham.
Well, your lordship uses the word sham, but there was never any disguising of what had happened. When Mr. Lagesse was confronted with what had happened, he made it absolutely clear what he had done, and the purpose of it was perfectly clear to the magistrate. The magistrate, having realized...
Was there ever any prospect that the second appellant would be in a position to repay 140,000?
Well, probably not, my lord. But that, in my respectful submission, is not the right question to ask. The right question to ask was the question that the magistrate asked: was that having found that these parties entered into the agreement in the passage that I've just read to you, he then asked himself the question, well, is that unlawful? And he found that it was not. The only possible basis. It should, I think, be remembered that the decision of Lord Wilberforce doesn't affect the fact that there should be a a strict construction of tax legislation. It simply says that construction of clear words should be in the context of the legislation in which they appear. And the only words which were really capable of dispute in the present case were the words which restricted the returning resident to prevent him from selling, pledging, or otherwise disposing of the motor vehicle. And if those couldn't be, if that was not,
we take a break now. We will take a break now for 5 minutes. Yeah.
yes. Well, Lord, I was submitting that there was no misunderstanding by the magistrate of the purpose of the transaction. What he asked himself was whether or not it was unlawful, and that was the correct approach. The only matter which could be complained about was the only words which were capable of dispute. The ones which were found in the regulations, and your lordships will find those at page 1479 of the electronic bundle, or possibly 1480. And it's 9 B1, which provide that the concession will be lost in the event that the person concerned sells, pledges, or otherwise disposes of the motor vehicle within 4 years of the date of its importation. The magistrate considered this in detail, and this is to be found at pages 318 to 320 of the bundle, where he considers under a subheading to carry out an unlawful act. And as he correctly states, the prosecution must prove beyond reasonable doubt that the agreement was to do an act which was unlawful. He then decided that there was no restriction which was covered what had happened, because there was no disposal of the vehicle within the meaning of the regulation.
Before you get to the question of sale, pledging, or disposing, isn't there a prior question of ownership? Whether this defendant who didn't pay anything towards the car, never possessed it, never used it, as far as one could see, would never pay anything for the car, was ever its owner. And isn't that what they're saying at page 769? That question of ownership was never addressed by the magistrate, where they say Respondent 2 may be owner on paper, never exercise any of the rights that an owner would normally exercise. He addressed that.
He was the legal owner. I think the magistrate does deal with that. I haven't got the reference at my fingertips, I'm afraid. But I think that there was no doubt that he was the legal owner, that the second appellant was the legal owner of the vehicle.
Because of a registration certificate?
Well, well, I mean, he was he had the rights of the owner. I don't think that would be affected. Perhaps I could come back to that, but the fact is that the case was run on the basis of we'll see the way in which it was treated in the Supreme Court. Yes, I'm just being reminded by so to speak, simultaneous WhatsApp communication that the prosecution did concede that he was the owner in their submissions before the Supreme Court. And I'll come to the reference to that if necessary. One has to look with respect to the way in which the case was run, and we'll see in due course that the Supreme Court spent some considerable time on this very issue as to whether or not there was a disposal, and indeed gave the appellant.
Sorry to interrupt you, Mr. Guthrie. Just on the question of how the case was run in the Supreme Court, don't we see that from the previous page 768, towards the foot of the page?
Would your Lordship just give me a moment?
Page 768.
Well, Lord, I think that is the summary.
Just to put my point to you, it's the section beginning. It doesn't matter. This is the more so given that there are alleged to be a number of steps involved in the sham transaction. It illustrates the need for a close analysis of what the statute actually requires.
Well, I think with respect.
And then just the next paragraph down. Secondly, as regards the scheme hatched by the respondents, we know there are a number of steps involved, and then so forth. So it does seem that in the Supreme Court, the prosecution was maintaining that this was a sham, and that it was a problem with the magistrate's judgment that he hadn't gone sufficiently into the underlying facts to determine whether that was so or not.
Yes, but I think with respect that one might say that was the Supreme Court re-expressing the way in which the matter was put by the prosecution. And indeed, we'll see when the hearing was actually taking place, because I'm going to take you to that in a moment. It won't take very long. It's quite clear that for the Supreme Court in argument was very much concentrating on the question of the disposal, in effect to the exclusion of the prosecution submissions, that this was to be seen as an overall sham scheme. And insofar as a sham is concerned, I mean, I think I already touched on it. The fact is that there was no pretense on the part of the appellants as to what had happened. It was clearly spelled out in Mr. Lagesse's interviews with the police and so forth, and that.
Just on that, I mean, there may be a sham which disguises a disposal as well as a sham which disguises ownership. And I thought, in answer to the questions from Lord Kerr, you accepted that there was never realistically any prospect of the second appellant repaying in accordance with the terms of the reconnaissance de dette. So why wasn't the reconnaissance?
Lord, I didn't accept that, because I don't accept the reconnaissance de dette was ever a legal document, and I don't. I said probably when Lord Kerr asked me the direct questions: could the student or the teacher pay for it himself? I mean, obviously the answer is probably not, but as a matter of fact, it's irrelevant because Mr. Lagesse paid for it, and Mr. Lagesse never pretended that he didn't, and he. In his
if I may, the case that was being put forward was that the second appellant had paid for it. He'd done so using monies that had been loaned to him by the first appellant, hence the reconnaissance.
I'm sorry if I omitted a step, but the reconnaissance to debt was not ever signed. But it's certainly the case that Mr. Lagesse at all times accepted that he provided the funds. And there was never any dispute about that. And as has been pointed out to me over the communication, it was accepted by the Crown that, but not by the Crown, by the director, that that Mr. Seeburrun was the owner of the vehicle.
I'm sorry to pick you up on this. The debt was signed. It was signed by the second appellant.
Yes, but not by Mr. Lagesse, who is my client, who is the first appellant, my client, or anybody on his behalf. I mean, and you'll have picked up that there was apparently legal advice taken in advance of this transaction. And I don't know, we don't have any details about it, but as I say,
I wonder if you could help me on this. My understanding was there was a draft lease at one point, and that was never executed. I may have confused that with the reconnaissance to debt.
I think I may have done too.
Debt was signed. Could we go to it?
If I can, I don't think I have it flagged at the moment.
I think it may be at page 820. That was, I was trying to locate it in the bundle. It's not in the index, but there's a translation, I believe, at page 820. I don't know where the original.
The French is at page 408. Page 408 for the French. The English is at page 820, and the lease agreement is 465, the French version, 843 for the English, if that helps.
Well, it may be that this is a matter which I can leave to Mr. Duval. So I'm rather conscious that I'm getting towards the end of my indented period, and I do have quite a lot to say. Well, not quite a lot, but I do have rather more to say on a subsequent point. What I was... Sorry, I think my Lord Kerr's connection is going in and out.
Yeah, can you hear me now?
I can hear you, but I can't see you, my lord. I can see you. Yeah. Yes, I can now. Yeah.
Okay, good. Well, let's proceed then.
I was, I think, answering one of the matters which were put to me by my lords in relation to the way in which the case was put, by saying that that passage in the Supreme Court judgment appears to be, if you like, a reformulation of anything which was said by the prosecution. And indeed, when one comes to look at see how the matter was dealt with during the course of the hearing, the court appeared to reject that approach in favor of the approach of the magistrate and the appellants, was that in order to find a criminal conviction for conspiracy to evade tax, it was necessary to show that the matter was unlawful, including the fact that there had been, or by reference in particular to the provision that I've shown you in the regulations, which prevented the disposal of the car within the period. And we would submit that the magistrate was right to adopt in a criminal case of a conspiracy to evade tax a strict construction of the provisions. And the question is whether the words in the regulations that I put before your lordships just now, I took you to them in the bundle, are sufficiently clear as to support a criminal offence of conspiracy to evade tax, however they are construed. And at this point, my lord, I do refer to the fact that this particular provision has been amended, and the new provision is to be found at page 1483. And I think it is 1484 or 5 under little b, about a third of the way down that particular page. The old provision has been substituted by this one, which requires the returning, or the person claiming the concession, to submit to the Director General not later than 1 month immediately following every period of 12 months from the date of valuation of the import, evidence that he's still residing in Mauritius and is in possession of the motor vehicle. So the test has been altered. Now, the fact that the provision has now changed may not be a complete answer, but it does support the submission that the previous words were not sufficiently clear and were not thought to include the simple parting with possession of a vehicle which one owns to somebody else for the purpose of allowing to drive it. For these various reasons, we submit that the magistrate's approach was not wrong, and that his reasoning should be supported, and that the defendants were entitled to their acquittal. My Lord, I then move on, if I may, bearing in mind that I have only a limited time left, to the points which relate to the hearing before the Supreme Court. And my Lord, may I say this first of all? This is, in our submission, a very important part of this appeal. In the present case, there was no motion for a retrial. There was a motion for a retrial in Lamto, as you have seen, and there would normally be one. There was also a motion for a retrial in the case of Ramdeen, which I haven't taken your lordships to, but it is one of the cases which is included with my supplementary note. And plainly, if the prosecutor is going to ask the court to order a fresh hearing, he should make it clear that that is what his intention, and the normal means of doing that would be to issue a motion in the proceedings asking for such an order. Now, we also have, my Lord, the parties' skeleton arguments in the appeal bundle. The appellant's skeleton argument, and I mean by this the appellant in the Supreme Court, in other words, the Director of Public Prosecutions' skeleton argument, that is at page 585. My Lords, I don't propose to look at it in detail, but the principal point is this: there is no reference in the skeleton argument to any possible retrial, nor, my Lords, was there any reference in the appellant's skeleton argument to the possibility that a serious irregularity had taken place in the proceedings at first instance. Nor was there any suggestion that the proceedings at first instance should be declared to be a nullity, which Section 96, subsection 5 envisages. There was, in fact, no reference to Section 96, subsection 5 at all. Equally, my lords, in the skeleton argument, there was no reference to Section 82(1) of the Constitution, or any invitation to the court to exercise its powers under Section 82, subsection 1 of the Constitution. Now, my lord, as you know, we have included the transcript of the proceedings in the Supreme Court in the appeal bundle. And I don't propose to ask your lordships to go to very much of it. But before I do ask you to look at it, Lord, can I emphasize that it is possibly most important for what it does not contain? There is no reference in the transcript of the hearing to the possibility of a retrial. It is simply not raised. There is no reference in the transcript of the hearing before the Supreme Court to any serious irregularity. There's no reference or suggestion that the trial should be treated as a nullity. It's not raised at any point. No reference again to Section 1965 of the Act. No reference to Section 82(1) of the Constitution. Indeed, there was no consideration of the court's powers at all. There was also, my lords, we submit this is also important, no mention of the fact that the court had a discretion. And your lordships will have seen from the words of Section 95(6) that the court may declare the trial a nullity and order a fresh hearing. And in Section 82(1) of the Constitution, the Supreme Court may make appropriate orders. And as we know from Seeburrun, they may include a retrial. My lord, the existence of this discretion, I think, is accepted by the respondent, and it is in fact referred to in the respondent's case at paragraph 47, where he mentions one of the cases where this is spelt out. It's a case called Alley and the State, which your lordships will find at page 1047. Because it was a matter of discretion for the Supreme Court whether or not it considered the order should be made in the interests of justice. 1047 is where the case begins. Maybe you're 1048, but the passage I rely on is on page 2 of the report, which you'll find at 1048 or 1049, I think.
1048.
1048. Yes, it's almost towards the foot of the page. It is generally accepted, and it is our view, that the exercise of the power to order a retrial should be subject to the interests of justice. I think in England and Wales, it refers to the Criminal Appeal Act, and it cites from a piece of Archbold, the decision whether to order a retrial requires an exercise of judgment involving consideration of the public interest and the legitimate interests of the defendant. The former was generally served by the prosecution of those reasonably suspected on available evidence of serious crime. If such prosecution could be conducted without unfairness to or oppression of the defendant, the legitimate interests of the defendant would call for a consideration of the time which had passed since the alleged offence and any penalty already paid, as to time since the offence, and then authority was made. Now, in the present case, because the possibility of a retrial was never raised, the matters which the court would normally be required to take into account in order to exercise a proper discretion whether to order a fresh hearing or not, was simply not referred to or taken into account at all. And there were a number of obviously relevant considerations which would have been raised and could have supported the argument that an order for a fresh trial would be inappropriate or indeed oppressive, which would have been available to the appellant and which he could have deployed had he thought there was any reason at all to do so. I mean, if I can just indicate what those might have been. The offence which was alleged to have taken place some 7 years before the Revenue Authority had originally proposed it should be dealt with by way of compounding, but had not answered the requests for details which first appellant had asked for. The first appellant, as I've already indicated, had cooperated with the investigating authorities throughout, and he'd been full and frank in setting out his part in the transaction. And indeed, it was those, if you like, the agreed involvement which was not challenged. The case in the intermediate court, which I ask you to note, had taken over 18 months from October 2014 until May 2016. The magistrate had found as a fact that the appellant had not intended to carry out any unlawful act. That, your lordships will find at page 323 in the magistrate judgment. The director's appeal had taken another 2 years before it came on for hearing. Now, all of those matters could have been brought to the court's attention in a submission that this would not be a suitable case for a retrial to be ordered. But in the event, there was no opportunity because of the way in which the hearing was conducted, because the retrial issue was not raised at all by anybody. And it's also the case.
I'm sorry, Mr. Guthrie, if we're against you on the question of the power of the Supreme Court to order a retrial, the point is the board, which you would have, say, advanced before the Supreme Court. If we are against you, and I'm do you say that we should remit the case either to the Supreme Court or to there ought to be a retrial in the circumstances, or is that something which the board itself should address?
Well, my lord, I would put it in this way. We say, and I'm going to take you to the reasons why we say it in a moment, that the hearing was unfair, not just for the reasons that I have given, but if we are right, my lord, and the hearing in the Supreme Court was unfair for any reason, whether because it didn't consider the matters or not, then the fact that there's an appeal before your lordship's board can't save it. If there's an unfair hearing before an appellate court, it must be set aside. That's what I would invite your lordships to say was the only thing that was the proper disposal of this appeal. Because, your lordships are not really in a position to exercise a discretion yourselves as to whether there should be a retrial or not. As I say, if the court's decision to set aside the acquittal was unfair, for any reason, and to order a retrial was unfair, then nothing can save it, and it should be set aside.
I'm not asking you to. I'm asking you to answer it on the question on the premise that we have decided that the Supreme Court did have the power as you pointed out, failed to take into consideration factors or matters that might have influenced its decision not so to do. What is the course that we should take? Examine that those factors and decide whether a trial should be ordered or should we remit it to it would be
My Lord, that would seem, with respect, to endorse the fact that there had been an unfair. I mean, they're remitting to the Supreme Court to endorse the fact that the hearing before the Supreme Court was not fair. And
well, I think I'm probably asking the questions to Mr. Guthrie. Let's.
Yes. Well, I have only one really area to take you to. And then that is the way in which the hearing was conducted, because it is, in our respectful submission, a further matter of unfairness that the appellants were in effect misled as to the basis upon which the case was to be decided. You'll just give me one moment. As I say, the hearing begins at page 661. If I take you to 663, we see Mr. Justice. I should perhaps just say this to your lordships: the composition of the court. Mr. Justice Hamout and Mr. Justice Madoub. Your lordships may or may not know this, but sadly, Mr. Justice Madoub is now deceased. And so that is simply something I mention. At page 663, at the foot of the page, at the very beginning of the Deputy Director's submissions, we see Judge Hamout, so to speak, opening the batting. You're expected to go directly to the point. We've taken cognizance of your ground. The point that they raise is that the charge was on the basis of conspiracy to do an unlawful act. Absolutely, my lords, and not a wrongful act. Yes, absolutely. And that when you look at everything, there was no element of unlawfulness in all that had happened between the parties. And then the Mr. Boyangali refers to the regulation, and then Judge Hamout says, which had been amended subsequently after the offence, the alleged offence, he says. And then he refers to the alteration of the regulation and says that's some sort of concession or admission, that there was some sort of loophole which he was purporting to plug. And then on the next page, the judge interjects, what are you going on? Are you suggesting it's your case and that it had been established that there had been either a sale, a pledge, or a disposal of the car? And Mr. Boyangali says, the facts have to be analysed in the general scheme of things. And the judge says, no, but this is a criminal case, and you are expected to prove strictly everything. And then over the page 666, the thing which will have to be interpreted at the end of the day, according to the respondents, is the meaning of disposal. And there has been a suggestion that to dispose of means to se défaire, to get rid of, to totally divest yourselves of the rights of an owner. So in effect, the court is, so to speak, setting out the area of dispute. And at page 669, Mr. Boyangali raises the question of possession in this context. And Judge Hamout says, you have to read the whole thing. It's a qualified thing. It's not possession only, Mr. Boyangali. You've got to be fair and reasonable. Otherwise, you will be taken as trying to mislead the court.
You're indebted for time. We have read all the references to this in your case. Is there any short? I mean, in which you can express the point that you wish to make from these.
I suppose if I have to take, I understand that your lordships have read and understood and will have formed a view as to whether I'm right in suggesting that really Mr. Glover was being told he was pushing at an open door, and so he rather naturally didn't push any harder, and so he didn't deal with a number of matters. But if I go to one point, the basis upon which the court eventually decided the matter appears to have been raised at page 693, where Judge Mahdoub says, you're saying the magistrate has made, and what he means is a literal interpretation of that particular section, whereas he ought to have a look at the whole scheme. If this is your argument, you have to present it in that matter. And then that is developed a bit, never part of your case according to your opponents. And then Judge Mahdoub, who eventually delivers the judgment, says, was this part of the, I'm on page 694 or 5, was this part of the case? As I will say, we now go on to statutory interpretation. Is this the manner that you ought to read into a tax legislation? If this is the case, as I said, you have to present your case in such a manner as to meet those things. One of the things that I have read in the skeleton arguments is tax law is to be interpreted very strictly. And Mr. Bangale agrees, says, yeah, absolutely, my lord. Really, the judge rejects the point that he's making and says strictly means strictly. One passage only in the submissions of the respondent at page 724 to 725.
But I've already told you we read these references. It's not really going to be very helpful for us to. Well, you the impact that these references have on the appellant's case.
I'm sorry, my lord. I'm afraid your connection is not as good as.
Well, let me repeat it as clearly as I can. We have all these transcripts.
Yes. Well, my lord, I don't wish to labour something unnecessarily, but I mean it is noticeable that when Mr. Glover makes the point about disposal, the court says, well, let's see what Mr. Bangale says about that. And then Mr. Bangale doesn't say any more about it. So it's hardly surprising that Mr. Glover left it as he did. But I won't say any more than that, my lord. We say that it's clear that the court appears to have been dealing with it in a certain way. It then came back with a judgment, which was dealing with it based on authorities, which incidentally had not been raised by the parties on either side. And in our respectful submission, that was not a fair way in which to proceed. And that if we're right, for that and any reason that the hearing was unfair, I repeat the point that nothing can save it. That judgment ought to be set aside, and Mr. Lagesse's acquittal should stand. But my lords, I am conscious that I've perhaps exceeded my welcome, and I'll stop now.
No, you haven't exceeded your welcome, right? That's as effusive as it ever has been.
Yeah.
Thank you very much indeed, Mr. Guthrie. Mr. Duval.
My lords, the second appellant joins in the submission of the first appellant in relation to the decision of the Supreme Court on count 1 of information. I propose to address the board on 3 additional issues which arise specifically from the written case of a second appellant. The first issue concerns the error in relation to count 5 of information, and whether, in the circumstances, the Supreme Court can be said to have delivered justice. The second issue is whether it was incumbent on the Supreme Court to make a specific pronouncement as regards the fairness of the appeal proceedings. The third and final issue is whether it was appropriate for the Supreme Court to order a new trial without considering whether the second appellant could still benefit from a fair trial. I propose to deal with those issues in the same order. In relation to the first issue, the second appellant submits that the Supreme Court failed to deliver justice. The respondent makes light of the fact that it escaped the Supreme Court, but the findings of the magistrate under count 5 of information remain unchallenged. The respondent's position appears to be that there is no harm done, since he is no longer seeking the retrial of a second appellant under that particular count. For the second appellant, however, the error of the Supreme Court is a grave one, which indicates that he has been deprived of his right to a fair hearing on appeal. I invite your lordships to turn to page 1039 of the bundle. At paragraph 104, the respondent deals with the question of whether the hearing before the Supreme Court was fair. At the end of the second line of 104, the second sentence, we read, "Now the special leave has been granted to appeal to the board. However, a hearing will take place at which all matters that were considered by the Supreme Court will be reconsidered to the extent that the appellants have invited the board to do so in their grounds," unquote. The point, however, my lords, is precisely that the Supreme Court did not consider crucial aspects of the second appellant's case. The averments of fact which the prosecution sought to impugn under count 5 of information went to the heart of the factual matrix of its case theory under count 1, the charge of conspiracy. The case of the prosecution was that the second appellant had never taken delivery of the car, was never in possession or control of the car, and that he had unlawfully disposed of the car by allowing the first appellant to have exclusive possession, control, and enjoyment of the same. The learned magistrate not only found that the prosecution had failed to prove that the impugned averments of fact were false, he actually found that the evidence of the prosecution case had established that they were true. This particular finding, my lords, is to be found at page 325 of the bundle, line 7, or 326, because I'm also referring to the hard copy. In resisting the appeal, the second appellant, in resisting the appeal, the second appellant insisted that the respondent must be taken to have accepted, firstly, that he took delivery and possession of the car, and secondly, that he allowed the first appellant to use the car for recreational and personal reasons. The second appellant further submitted that these facts, which could no longer be disputed, could not be reconciled with the case theory of a prosecution under count 1 of the information. At the end of the day, my lords, the second appellant's argument in relation to count 5, which the respondent now concedes was properly raised, was simply ignored by the Supreme Court. In the circumstances, the respondent cannot be heard to say that the hearing of the appeal was a fair one. In its judgment, the Supreme Court merely noted that ground 4A of the grounds of appeal was dropped after a preliminary objection taken by the second appellant. There is not a single word written about the magistrate findings under count 4, nor their relevance to count 1, under count 5, nor their relevance to count 1. This omission led the Supreme Court into error. I invite your lordship to turn to page 769.
Yeah.
769 or 770. My friend, Mr. Guthrie QC, referred to that part of the judgment where the court found that it was, I quote, arguable at the end of the day that the owner on paper, meaning the second appellant, have never exercised any of the rights which an owner of the car would normally exercise, and here the weight of the financing agreement in maintaining the state of affairs demands to be analyzed thoroughly, unquote. My lord, this is not arguable when we take into consideration findings of facts made by the magistrate, not challenged by the respondent and left undisturbed by the Supreme Court. Furthermore, this error is not without consequences on the ability of the intermediate court to duly administer justice should there be a new trial. It stands to reason that a fresh factual analysis in relation to count 1, the count of conspiracy, will necessarily include the issue of delivery of the car, will necessarily include the issue of the nature of the possession which appellant number 1 was allowed to enjoy. Was it exclusive possession or not? The Supreme Court, however, did not set out the parameters within which such a fresh factual analysis is to take place, as was necessary to ensure that the prosecution is not allowed to revisit matters of fact which have been conclusively determined by the magistrate under count 5. Like Mr. Guthrie rightly pointed out, a second bite at the cherry. In relation to the first issue, my lords, the second appellant submits that the Supreme Court has failed to duly deliver justice in 3 material aspects. Firstly, its failure to acknowledge that the findings of magistrate in relation to count 5 remain unchallenged. Secondly, its failure to consider whether such findings could be reconciled with the case theory of the prosecution under count 1. And thirdly, its failure to consider the implication of ordering a new trial of the appellants under such circumstances. Turning to the second issue, the second appellant submits that it was incumbent upon the Supreme Court to make a specific pronouncement in answer to his arguments relating to the fairness of the appeal proceedings. There is indeed a second, equally important aspect of the case of the second appellant on appeal, which was simply ignored by the Supreme Court. It arose from 2 related complaints. Firstly, the prosecuting authorities failed to inform the second appellant with precision of the case he had to meet. And secondly, the respondent unfairly argued on appeal that the evidence adduced at trial established a case which was not properly put before the magistrate. The respondent deals with these complaints in its written case at page 1042, paragraph 114 and 115. The respondent submits that the second appellant is in fact inviting the board to make the same error as made by the magistrate. However, the respondent has nothing to say about the failure of the Supreme Court to make any pronouncement in relation to those complaints. It is humbly submitted that such a failure is the more disturbing in view of the observations of the bench in the course of the hearing of the appeal. At page 1007, if I may take your lordship to page 1007, which is the written case of the second appellant. At paragraph 37 is reproduced the exchange to which Mr. Guthrie referred. And may I say, with utmost respect, that this extract reveals a certain degree of frustration from the bench when it did not get from State Counsel what it felt the case could have been. In fact, Mr. Guthrie cited the intervention from late Honorable Madder. And if we turn to the next page, 1009 or 1010, just before paragraph 38, we have this revealing last comment from Mr. Madder. No, but we are not getting it from you. So whatever the bench was expecting from State Counsel, the bench did not get. There is more. At page 7 to 6 of the bundle, we have, at this point in time, Mr. Glover, Senior Counsel, is on his feet for appellant number 1. And again, we see the intervention of late Honorable Madder. And allow me to read these because I believe it is more than relieving. As from line 9, and who dispose of what? Because now from the submission, again, Mr. Bengali, maybe you could clarify what you seem to suggest is number 1 was the one which actually in reality imported and did the whole thing. Whereas when we look at the case before trial, it would appear that number 2 imported for the benefit of number 1. And this is where I don't really get where you are coming. And further, at line 20, you see the point. There is a difference between number 1 doing the whole scheme, but then you have number 2, which seems to be your case in the court below, importing for the benefit of. My lord, the argument of fair hearing was raised squarely on the authority of Jugdut versus ICAC, 2016 Supreme Court Judgment 187. The part of the submissions before the Supreme Court is to be found at page 732 or 1 from line 10. It is submitted with respect that the failure of the Supreme Court to make a specific pronouncement to answer an argument properly raised, calling into question the fairness of the proceedings before it, is inexplicable and is inexcusable. The following 3 statements of principle are, I humbly believe, uncontroversial. Firstly, the constitutional right to a fair hearing extends to appeal proceeding. Secondly, a person whose appeal against his conviction is dismissed has a right to be given the reasons for the court's decision. Thirdly, whilst an appeal court is not obliged to provide a detailed answer to every argument raised, the unsuccessful appellant is, I quote, entitled to be assured that his case has been properly considered, unquote. This quote, my lords, is from Lang versus the Queen, 2013 QPC 14. The actual extract, it's as on the bundle, page 1055, paragraph 15. It is humbly submitted that a person whose acquittal is quashed following an appeal also has the right to know exactly why the appeal has succeeded, and is equally entitled to be assured that his case in resisting the appeal has been properly considered. The second appellant resisted the appeal of the respondent by, amongst other things, calling into question the fairness of the proceedings because of the manner in which the respondent pursued that appeal. In the light of the judgment of the Supreme Court, the second appellant has no assurance that his case was considered, let alone that his case was properly considered. In relation to the second issue, the second appellant submits that the failure of the Supreme Court to make a specific pronouncement as to the fairness of the appeal proceeding constitutes an infringement of his constitutional right to a fair hearing. This leads me, my lords, to the third and final issue, and the question of whether the second appellant can still benefit from a fair trial. May I invite your lordships to turn to page 1043, and it may be in the electronic bundle it's 1044, but I am referring to paragraph 118 of the respondent's written case. So 118 reads as follows. Finally, it is to be noted that the appellant's argument that he has not been aware of a case which he has to meet would, if well-founded, meet the test of serious irregularity. If the board concludes that the argument has no substance, it will, subject to the other grounds, dismiss the appeal and the Supreme Court order for a retrial will stand. However, if the board concluded that the argument was meritorious, the Supreme Court order for retrial would equally be the appropriate order, unquote. As we have seen earlier, it was on appeal that the second appellant relied on the authority of Jugnut versus ICAC and others to argue that he was being deprived of a fundamental feature of a fair hearing. If we turn to page 733 or 734, at the top of the page I'm referring to, we see Court Honorable Ahmed Judge, page question mark. And I'm inviting your lordship to look at the paragraph under Mr. H. Duval SC. The argument raised was not about whether there had been a serious irregularity at trial. The argument made was that there could not be a fair trial if the respondent was allowed on appeal to change tack and champion a case which was not properly put forward at trial. If we go to line 13, allow me to quote, "Throughout this trial, the case that the respondent's number 2 had to answer is that he illegally, unlawfully disposed of his car in favor of respondent number 1. That was the case he had to meet. What do we have today? No, our case is that respondent number 1 was always the owner. He was always the true importer. So much that the issue of disposal does not even arise. How can we therefore, my lords, say, if this is the makeshift position of a prosecution, that the respondent number 2 and any other respondent for that matter can be said to have had a fair hearing, unquote. This question, my lord, was put squarely to the Supreme Court, and this is another question that it simply ignored. It is a matter of concern that the respondent should invite the board to infer that the Supreme Court has ordered a new trial in the exercise of its power pursuant to Section 82(1) of the Constitution. Had the Supreme Court duly delivered justice and properly discharged its duty to give reasons, it would not have been left to this honorable board to decipher from the judgment the precise source of the power which the Supreme Court purported to exercise to deprive the second appellant of his constitutional protection against double jeopardy. Let me pause here to address, if I may, the question from Lord.
I'm sorry to interrupt. Longer?
No, my lord. 5 minutes at the most.
Okay, do proceed then.
So I will leave the question of Lord Briggs if he wants to if for another later maybe. So I go back to.
Well, if you want,
Yes. No. It is common ground that the power under Section 821 of the Constitution is to be exercised for the purpose of ensuring that justice is duly delivered by the subordinate court. It is one thing, therefore, for the respondent to argue that the Supreme Court had the power to order a new trial under Section 821 of the Constitution, and quite another to argue that there was a proper exercise of such power when there is no indication that the Supreme Court has considered the purpose for which it was exercising its power. In relation to the third and final issue, the second appellant submits that had the Supreme Court deemed itself duty-bound to consider and to answer an argument properly raised, it was bound to come to the conclusion that it was no longer possible for the intermediate court to deliver justice in view of the lashes of the prosecuting authorities. To conclude, my lords, it is submitted with the greatest of respect that even if the board is minded to accept that the Supreme Court purported to exercise its power under Section 821 of the Constitution, it was clearly not an appropriate exercise of power by the Supreme Court. The second appellant did not benefit from a fair trial at hearing, and therefore prays that the order of the Supreme Court be reversed and the orders of acquittal be restored. Unless I can assist you further, these are my submissions.
We'll adjourn now and we'll sit again at 10 minutes past 2. Thank you very much.